Thank you, Rich, for having me today. Thanks, everybody, for coming and taking an interest in this. I know there are a lot of lawsuits going on in the courts right now. It's hard to keep track of them, even because there's so many going on. I can't even keep track of all of them. I did a decent amount of research trying to figure out the extra stuff that I didn't know so that we could talk a little bit about it today. I'd like to say, first of all, I'm a criminal defense attorney in San Diego, so that's more my background. I got into law and to trying to be a lawyer because of my love for the Second Amendment. I would do things on the side to try and help people with their gun rights. So people are in restoring their rights after maybe crimes that they've had in the past, or also I help out with current gun crimes as they're prosecuted in San Diego and throughout the state of California. So I know when we talk about these 2A legal battles, it's kind of hard to figure out where a lot of them are at because there is no set path exactly for a lot of them. So what I wanted to talk today about is the federal court system, and particularly in relation to challenges regarding the Second Amendment. So the Second Amendment, of course, we know it guarantees the right to bear arms, and that has been the subject of numerous legal disputes in our nation. Understanding how these challenges flow through the federal court system provides insights into the life of a Second Amendment case, so you can kind of figure out where something is going based on where it's been so far. Most people, even some lawyers that I talk to, they just practice at the state level in the district courts or the superior court here, and they don't know what happens to the case after it goes even further. So I assume many members of the public would like this information to try and figure out where it's going as well, so they can gauge a lot of these cases. The judicial branch is one of the three branches established in our Constitution. The federal court system of the United States is a vital component of our democracy, ensuring justice and the rule of law. It serves as a safeguard for the individual rights and is the cornerstone of our legal system. The federal court system is composed of three distinct levels. So whenever a court starts off with a case, it always starts in the district court level. And then the district court is the lowest. After the district court, if somebody loses that case, they want to appeal it, it goes up to the Court of Appeals, which is the second level. And then the third level is going to be the Supreme Court, which is the law of the land, as we always say. So right now, where we are currently sitting is in the Southern District of California, so we're in their jurisdiction. That's why a lot of San Diego County gun owners cases are heard in the San Diego Southern District of California, and that's where Roger T. Benitez is a judge. Individuals and also organizations like San Diego County gun owners who believe their Second Amendment rights have been infringed, they file complaints, and that seeks the protection or restoration of those rights, and that's how the cases get started. The journey of the Second Amendment case starts with the plaintiff filing that complaint, and they outline the alleged violation of their rights. They present arguments and legal claims citing specific laws or regulations that they believe infringe on the Second Amendment. And the defendant typically is a government entity responsible for enforcing those laws or regulations. So whenever you see the cases, most of them say so-and-so versus Bonta. Bonta is the Attorney General of California. So whenever California makes a terrible law that we want to challenge, we always have to go after the top law enforcement official, which is the Attorney General. So right now it's Bonta, but in recent past, it's been Kamala Harris, Javier Becerra, and now it's Rob Bonta. The initial pleadings, once those are filed, the case enters into the pretrial phase. During that stage, both parties engage in discovery. So there's a back and forth game of gathering evidence and information to support one side. So you'll see a lot that one side enters a brief, which is just kind of a summary of what they're trying to argue for. And then every time a brief is entered, the other side gets to oppose it, and they get to say their side and why their side is correct, and any of the historical or other challenges that have already been made that are relevant to it in the district or in districts like it. So Analyzing the individual impact of the rights and presenting expert witness or statistical data to strengthen their arguments is always what they will do as well. So there are a lot of gun experts that get used. If you listen to any of the San Diego County gun owner cases or any of the other FPC cases or CRPA, they all involve experts that have written books on guns and have written numerous things around the subject, and that's how they get to be qualified as experts. Then they take. So the problem is that these pretrial phases, they end up never reaching a settlement. So the case proceeds to trial, and at the trial in the Second Amendment cases, they can involve careful examination of the historical context, the legislative intent, and the precedent related to the right to bear arms. So, of course, the plaintiffs are always arguing that we have the right to do this because X, Y, and Z, and the state is always arguing that they have the right to regulate it based on X, Y, and Z, and usually they both point to legal precedents, which is going to be important when I talk about the Bruin decision and how that impacts it in a little bit. Most cases do not require a jury. So these are not jury trials, these are bench trials. And that is where the judge decides the outcome without the use of a jury. So whenever they're doing this, we don't want to leave it up to a jury to decide these constitutional changes. So in order to do that, we just give it to the judge, and the judge is the best person to interpret what's going on with the Constitution and how the evidence will prevail with that. So after they make a decision after the trial, if either party is dissatisfied with the court's decision, which always there's one side who's a winner and one side who's a loser, so somebody's always dissatisfied, they may choose to appeal the ruling. So then it goes from the district court to the Court of Appeals, and this takes the case to the next level of the federal court system. The Second Amendment challenges that reach this stage are scrutinized by appellate judges who review the district's decision. They examine whether the lower court correctly applied the law. They consider the relevant precedents and protected or infringed upon the Second Amendment rights that are at stake in the specific case. It's also worth noting that the Second Amendment challenges can have significant implications for interpretation and application of constitutional rights. These cases often involve debates over the scope of the right to bear arms, such as the legality of certain firearms, restrictions on carrying weapons in public, or regulations on background checks. So all the Second Amendment cases, they challenge different things, and you need to look at the scope of the right to bear arms, and that's why sometimes you've heard it very heavily debated, the text of the Second Amendment, and what actually the right to bear arms means. The word bear itself, some people say that it must be something that you can hold. Some people say that it must be something that you just may own and possess. So there are different interpretations of that. And the judge's opinions when these rulings are made is what is related to when they try and look back and see how it was interpreted, so that at the lower courts later, when California inevitably makes worse laws again, we can point to what happened at the Supreme Court and say, this is how they interpreted it, this is why it is the way it is, and this is why it's infringing on our rights. The Court of Appeals decisions can shape the legal landscape, establishing more important precedents, influencing future Second Amendment cases. So even wins that we have within the Court of Appeals in the 9th District, so we're in the 9th District of the Court of Appeals, and that includes pretty much the Pacific area. It also includes a couple other states like Arizona and some of the surrounding states, including Hawaii too. So anything that happens in the 9th District, if it happens at the Court of Appeals, then it's going to affect us immediately because we're in that district. Sometimes we can point to decisions that were made in other districts. So sometimes you might hear cases that happen in Texas or in maybe the Carolinas or somewhere else. And those cases sound that they're working out favorably because they have favorable judges over there. We can use that in our briefs when we try and submit them for different challenges. However, they don't need to take that as the law of the land because it doesn't come from the Supreme Court. It just comes from the districts, and it's not within our district, so they don't have jurisdiction over us. So that's why when something happens somewhere else, it doesn't always affect us overnight. So that Bruin decision, as I was mentioning, that was a landmark case for how the Second Amendment law will be determined and how cases will be judged. And I'll get more into that in a little bit when we talk about scrutiny. So the next thing that would happen is if the party remains unsatisfied with the decision of the appellate court once that case has been appealed, they may have the opportunity to petition the Supreme Court, and that's the final arbiter of the law. Usually the losing side for that case will apply for a writ of certiorari, and that will get the case heard. However, there are thousands of cases that are trying to appeal to the Supreme Court every single year. That's why we've been waiting forever for a Second Amendment case to get up there before Bruin. Because the last ones before that, there was the Heller decision, which I know a lot of people know about, and then also the McDonald versus Chicago, and that was in 2012. So that was a pretty long time ago, and we haven't had anything about the Second Amendment ever since. So we only had that Heller decision to go off of, and that made it very difficult because the level of scrutiny was changed. So with the thousands of petitions that they get a year, only about 100 cases are chosen to go to the Supreme Court of the United States each year. It carefully considers the constitutional issues at stake. They also look at the circuit split among the Court of Appeals. So for example, when you look at the Second Amendment cases, we had a lot of splits because some districts say we need to judge it this way with the lower sense of scrutiny, and then the other ones say that we need to have tighter scrutiny on it, and to determine which is correct, that's why they want to take the cases at the higher level. They also need to clarify and establish legal principles surrounding the laws that are challenged. So that's why it changes all the other ones at the lower levels and how they look at everything. If it gets picked up by the Supreme Court of the United States, then we get results one way or another, which is really nice because a lot of our cases, they take forever to fight. They're really hard, and as you know, a lot of the cases don't just breeze through our system. It takes years to get to the Supreme Court, and even if a case gets there, a lot of the time it'll get held up. Other cases will get held up waiting on rulings for other cases that establish the precedent. So when we have a bunch of cases right now, when I try and give you this update, it's kind of difficult because a lot of the cases are on hold right now. And they're on hold because they're waiting to see what happens in different cases above it. So for example, any concealed carry case that was being challenged in the district courts or in the Court of Appeals throughout the United States, they were all on hold waiting for Bruin. And then when Bruin was decided, then they said, okay, now we can use that standard to tell us how to judge these lower cases and what to do in our own districts, because that was supposed to solve the split decision. So we also have this thing called an en banc hearing, which you might have heard of. In California, or the Ninth Circuit, I should say, we get these pretty often because at the district level, we'll win a case, then it'll get appealed to the Court of Appeals at the next level that I was talking about. And then that one will also have a problem because we win that one. And if we win that one, then the district says, no. Even though you won that, we're not going to give you the win on this one. We're going to have an en banc hearing. And what happens with the en banc hearing, with the en banc hearing, what a lot of people don't know how it works is because it's not very common, but it is to gun cases because we usually get them pushed back. Because obviously, as everybody knows, there are a lot of liberal judges within the 9th District, and that whole district overall, if we get a couple favorable judges to gun rights and we win a case, they're not going to be okay with that because the only place to go with it next would be the Supreme Court. And they know that the judgment is not going to get changed for years if they just go straight to the Supreme Court. So what they do is that en banc hearing, and the way it works is to consider reconsider a previous decision made by a 3-judge panel in order to ensure uniformity and consistency in the court's rulings. So the Ninth Circuit Court of Appeals is one of 13 federal court of appeals in the United States. It covers a vast geographic area, including 9 western states and 2 territories. So typically in the Ninth Circuit, when they begin with a 3-judge panel hearing, so any court that goes to the Court of Appeal, or any case that goes to the Court of Appeals, that's going to be challenged first, and it's going to be heard by a 3-judge panel. Generally, in the district level, it'll just be one judge who takes care of everything. And then when it goes up to the appeals, they want to make it more consistent, so they put 3 judges on it. And this 3-judge panel, they're on there, and it's usually randomly assigned judges who consider the arguments. They review the record and issue a decision. Once they're dissatisfied with that, or the losing party is dissatisfied with that, they're trying to seek a rehearing en banc. So the process for that, initiated by a filing a petition for a rehearing en banc, the petition is reviewed by all the active judges in the Ninth Circuit. And I looked it up today just to get the most current number on that. We have 29 judges in the Ninth Circuit. And if the majority of those judges vote in favor of a rehearing of a case en banc, then the petition is granted and the case proceeds to an en banc hearing. So it's not just one person making a decision on this, but you can see how having a bunch of liberal judges makes it very difficult to get past this, because if they see something that they don't agree with or like, if the majority of, let's say 2/3 of them are liberal judges, they only need half of them to say, we want to rehear this case. So then they'll try and rehear the case. It's granted the petition. And then it's primarily based on the decision to grant the en banc hearing is primarily based on the significance of the case, whether it presents legal questions that require clarification or resolution. The Ninth Circuit typically reverses en banc hearing cases for cases that involve significant constitutional issues, which of course are Second Amendment issues, and they conflict with existing precedents. So if somebody uses a precedent wrong, or they think they made a bad decision at one of the lower levels, then that's what they're trying to fix. That's what it was designed for anyway. But now it's been a little harder. So once the en banc hearing is granted, all the active judges in the Ninth Circuit have the opportunity to participate. So that's what makes it a little worse, and why you can see they always get reversed, because the judges who want in on these cases, they get to just go in there and they get to submit themselves for it. So the panel will consist of a chief judge and any of the active judges in the circuit that want to take part in this. Senior judges who are semi-retired and have a reduced caseload do not participate in the en banc hearings unless they were on the original 3-judge panel. One thing that a lot of people don't know, and I didn't find out until recently, is that there are a lot of retired judges that get recalled into service. Usually when they're waiting to fill spots, or something along those lines, when they just have a shortage of judges either retiring or they just have a huge caseload, which they always have a huge caseload, so they almost always have a reason to get more retired judges back on. During the en banc hearing, the judges review the case and engage in oral arguments presented by the parties, so each side gets to present their argument. The purpose of the en banc hearing is to provide more comprehensive discussion of and analysis of the legal issues at hand. After the hearing, the judges deliberate and eventually issue a new decision, and that will supersede the earlier decision made by that 3-judge panel. So how it works is, usually for a Second Amendment case, we'll win at the district level, and then we'll appeal it to we'll win, the government will appeal it to the Court of Appeals. If we win again, and they said that we were correct at the district level, then we will win, and they will try and go for that en banc hearing. And then the en banc hearing, they have that, and generally we will lose because of the judges that include themselves on that. They're supposed to be rare, but they are not rare for Second Amendment cases. They come after all of those because that's something that they should be carefully selecting, but instead they think that it warrants participation by all the judges, because the theory of why you started doing that is to try and right the wrongs. But for this, it actually creates participation of these activist judges who are able to do what they want, and they know that when you have an en banc hearing, there's a very slim chance of that being overturned in the Supreme Court because it's such a hard road to get to the Supreme Court. So in conclusion with that part, the en banc appellate hearing is in the Ninth Circuit, and it arises when the party case seeks a rehearing after the initial decision by a 3-judge panel. If the petition for the rehearing is granted by a majority of the active judges, the case proceeds to that en banc hearing, and that involves all the judges that want to include themselves in the Ninth Circuit. That process ensures that significant cases receive a more thorough review and contribute to the development of consistent legal principles within the circuit. So the federal court, as you can tell, it plays a crucial role in adjudicating the Second Amendment challenges. From the district courts to the Court of Appeals and then the Supreme Court, these cases undergo a rigorous legal journey. The federal courts analyze the constitutionality of the laws and regulations, evaluate the impact of individual rights, and shape the interpretation of the Second Amendment for our nation. And now the Bruin impact I'm going to talk a little bit about. That, for the people who do not know, was the New York Rifle and Pistol Association versus Bruin. That was decided in June of 2021 by the United States Supreme Court. That is the big one that's changing everything for us. That was a case that was in regards to concealed carry holders. So that was about proper cause. And that said the constitutionality of New York's law that restricted individuals from carrying concealed handguns outside their home without proper showing of good cause for self-defense. The case raised important questions about the scope of the Second Amendment and the ability for states to regulate carrying firearms in public. We know that one because it was the law of the land. It affected us immediately, but only in the fact that it was specific to that challenge about proper cause. So in San Diego, if you're applying for a CCW, the only difference to us now is that you don't have to write that little statement that says that you have good cause. And then because before that in not San Diego, well, San Diego pre-2018, I should say, because San Diego County Gun Owners is very important in trying to change the policy of the sheriff, because each state for constitutional, or there are different ways to carry in each state. So for example, over half the states now are what they call constitutional carry, where you don't need to get any kind of permit. And then they have a split on the rest, which are either shall issue cases or may issue cases. So in the states where they have shall issue, basically as long as you pass a background check, you're good. If you were in the may issue, then that's where they use that standard that was subjective, and if they wanted to, they could basically just deny you for any reason they wanted to, as long as your proper cause wasn't good enough. So in our good cause statements, the sheriff for years used that as an excuse to not give anybody CCWs in San Diego. In 2018, San Diego County Gun Owners was out on the corners. I was doing it myself, holding up a Dave Myers sign because he was the one who was running against Gore. And at that time, Dave Myers is very favorable to the Second Amendment and wanted to give us CCWs. So that's why we got on board behind him. But eventually, after a while, Gore figured out that that was a bad idea, bad policy to not allow good people to have the right to defend themselves in public. So he changed his decision on that, and it made it a little bit easier for us in San Diego. However, the rest of the counties where the sheriff issues the CCWs in the rest of the state, it just depended on who you had as a sheriff. So if you lived in LA County, for example, you weren't going to get a CCW, even though we could get them in San Diego, which is kind of crazy because, of course, when you do get a CCW, it's good for the whole state. So people in San Diego, we could get our CCWs here and we could ride up to LA and we would be allowed to have them. However, if you lived in LA, you weren't allowed to have them, and you couldn't go anywhere else with them because your sheriff wasn't allowing you to have them. Sheriff Villanueva has changed his views on that, it seems like, a little bit more recently. But everyone knows what's going on in LA right now. They've got all sorts of crime, way worse than us. But they've had to change that for those reasons. So the impact of the New York Rifle and Pistol Association versus Bruin decision is significant as it clarified certain aspects of Second Amendment law. However, it's important to note that the new court's decision was relatively narrow. So it was just about that proper cause. But the most important thing is it did explain the level of scrutiny applied to such regulations. So they couldn't just arbitrarily tell us that we were wrong and that we didn't have the right to do this. They had to take that away, and they say you need to give them a good reason of why you're not allowing them to have their Second Amendment right, because it is a right. It's not like a driver's license where it's, a privilege. So with that in mind, they gave it a higher level of scrutiny, which I'll talk about in a little bit here. So for New York, it had immediate implications for their carry laws, and ours, of course, too, because the law of the land changed it. So our requirement for the good cause went away, and the same thing for New York. They had to completely re-overhaul everything that they were doing for their CCWs. They actually later made another policy for their CCWs about how you could obtain them in New York, and that one was probably worse than the first one. So that one immediately was trying to be challenged. They're trying to bring that up to the Supreme Court of the United States right now as an emergency hearing, but that one is probably still going to be a little while before that's decided.
Is that the sensitive places thing?
The sensitive places thing is part of it. That's part of what they challenged, because the Bruin decision, part of the opinion said that, so we're going to take away this standard, but you can't put a bunch of other arbitrary standards in place of it. And what they said was, specifically, you cannot make the entire island of Manhattan a sensitive place. And this gentleman and I were talking about this a little earlier, because that's exactly what they did. So they changed it, and they're trying to do this in California right now too. You said it was SB2, correct? And they're trying to pass that at the state level right now. That is going to try and infringe on our ability to carry in certain places. It used to just be, you just couldn't go to schools with it, which still doesn't really make sense to me either, but they're trying to say that there are certain places that are sensitive places and that there's an understanding that you're not allowed to carry there, which I get, but they can't make the entire island of Manhattan a sensitive place, which is essentially what they did in their new law. And like I said, that's what they're trying to do in California too. They're trying to make it so you can't really carry anywhere in California. Everywhere's got to be a sensitive place. So that will be challenged as soon as they try and do that against us. I'm sure of it, if it even gets that far. So scrutiny. When it comes to constitutional challenges, the levels of scrutiny refer to the test or standard applied by the courts to evaluate the constitutionality of a law or government action. These standards determine how closely the court will review the challenged law and how likely it is to be upheld. There are generally 3 levels of scrutiny: strict scrutiny, intermediate scrutiny, and the rational basis test. So the first one, strict scrutiny. Strict scrutiny is the most rigorous level of scrutiny and is the most favorable to the citizens. It is applied when the fundamental right or a suspect class is at stake. Laws subject to strict scrutiny must serve a compelling government interest and be narrowly tailored to achieve that interest. So for example, you cannot say that people can, like a blanket curfew law, that's too broad. So they can say, there are a lot of bad things happening at night between this time and this time, so we just want to make sure nobody's outside at that time. But that's not narrowly tailored enough, because it's going to just make sure that nobody can go out after these times, and if you're coming home from work or anything else, it'll get in the way, and it doesn't actually help anything. So for example, the burden for a lot of our Second Amendment ones, that's what we want, is strict scrutiny. That would be the most favorable to us, but we didn't exactly get that. So the burden is on the government to demonstrate that the law is necessary to achieve a compelling purpose and that there must be no less restrictive alternatives available. So that means that they've tried everything that they could, and the only way that they can that their interests can be fulfilled is through this law, and that they've tried everything else. So when it comes to that, fundamental rights are usually at stake, which we all think Second Amendment, obviously fundamental right. So those are protected by the First Amendment. So First Amendment challenges, those are always strict scrutiny. So freedom of speech, freedom of religion, etc., and the right to privacy, those are typical for strict scrutiny. Additionally, laws that classify individuals based on a suspect class, such as race, national origin, or a lineage, that also triggers strict scrutiny. Being as the Second Amendment comes right after the First Amendment, logically, we would all think that the Second Amendment challenges require strict scrutiny. However, that is not how the Supreme Court sees it. The next one would be intermediate scrutiny. Intermediate scrutiny is applied to the laws that involve important but not fundamental rights, or laws that discriminate based on a quasi-suspect class. So that is like kind of half classification. Under intermediate scrutiny, the government must demonstrate that the law is substantially related to an important government interest. So that's the rule for that one. The law must serve a significant purpose and must not be substantially overbroad or under-inclusive. Examples of rights subject to intermediate scrutiny include gender-based classifications and laws related to commercial speech. In these cases, the government must show that the law is substantially related to an important government objective. So substantially related to an important government objective is the important part there, where the other one is a compelling government interest, and it also must be narrowly tailored. In the intermediate scrutiny, there's no requirement that it's narrowly tailored. It's just that it must be substantially related to an important government objective. So the burden is on the government, which is important too, because we need to put forth the evidence that it's infringing upon us, and it's their burden to show how it's not infringing upon us. However, these cases can go either way. A lot of the times, sometimes they can meet that standard, a lot of the times they don't, but that is why it's a scary standard for us to have. We don't want intermediate scrutiny because it really can go either way. It's kind of a crapshoot when it comes to those. The third one is the rational basis test. The rational basis test is the most lenient of all the scrutinies. It applies to most laws that do not involve any fundamental rights or any suspect classifications. So under the rational basis test, the law is presumed constitutional as long as it rationally relates to a legitimate government interest. So a rational relation to a legitimate government interest, that can be done very easily. So the government doesn't have the burden anymore. The burden is on the challenger, whoever's trying to challenge that law, and they're trying to demonstrate that the law is not rationally related to the government's legitimate purpose, or that it is arbitrary or just completely irrational. The government almost always wins these because they don't have the burden anymore. It's on us, and everything that they have can be a legitimate purpose. So it's very easy for them to meet their standard on that, and we almost never win those. Especially when it comes to like taxes and things like that. That would be an example, one of those two. Whenever they tax us, they say it's related to a important government purpose, and boom, we're done. So all these levels of scrutiny, they provide the framework for the courts to analyze the constitutional challenges, but they're not always applied in strict and consistent manner. Sometimes the line between the levels of scrutiny can be blurred, and there are variations or hybrid approaches depending on the specific context or legal issue involved. The Bruin decision had major implications because it's developed its own standard for Second Amendment cases. Specifically, that decision stated text informed by history and tradition. So whenever anyone's reading any Second Amendment law now, it's not strict scrutiny, it's not intermediate scrutiny, it's somewhere in between. So whenever they look at that, they need to look at text informed by history and tradition. So the way that you would think about that is it must be supported by the history at that time, which is the time of the Constitution, and the traditions that they had in place. So you look at the text and the text on its face, and you see if it violates any major rights. And then you look at the traditions that were in place at the time. For example, I try and think about the 10-day waiting period to pick up a firearm. So if that's being challenged right now, that's the Richard case, right?
Yeah.
So that's the Richard case. That is the San Diego County gun owners right now being challenged. And that one is the 10-day wait period. So that has, it would have had to have the same type of law back in the beginning of our country. But we all know there was no 10-day wait period. There wasn't a 2-day wait period. There was nothing like that in the beginning. So the government has the burden where they have to explain that there was a law back then. They have to cite what it was, and they have to say why it was okay back then, and why it was in line with history and tradition. So they look back to things, sometimes they go even further because they look at England, who of course we fought a war to get off our backs, but with them they had laws about carrying, as you can imagine, that you had to actually carry open, believe it or not, back in the day. They thought that it was not a nice thing to do to conceal your weapon, but that was a different time, of course. Nowadays, so they would have to show that they had the similar laws back then with the similar spirit and purpose of the current law being challenged. This makes the government look to cite laws related to waiting periods in history. However, the government can only cite laws that are roughly older than the 1900s. They can't do anything that was recent, which is a huge thing for any Second Amendment advocate because we didn't really start seeing too many gun laws in place until about Reconstruction era in the 1800s. So before that, there was really not that much on the books. So whenever they use this new standard, it's going to be very, very difficult for the government to try and push back and say, hey, in 1801 or 1803 or right around the time of the Constitution, we had this law that was similar. Because all the laws that they're making now, most of them they hadn't done before. So that is something else to consider. And it's going to make a big difference for all these things nowadays because they didn't have a good cause standard back then. That's why that got changed. It's a terrible standard. So prior to that decision was the Heller standard. That was a 2-step test. And first they would decide if the banned item was in common use. If it was, then the second step of the interest balancing equation would take place. So the government would say, or the judges would say if the government's interest outweighed the burden on the citizen. So this was a terrible standard for us because it gets closer to intermediate scrutiny and it provides more wiggle room for those activist judges that want to ignore the Second Amendment. The levels of scrutiny and constitutional challenges determine the degree of judicial review applied to the laws or government actions. Strict scrutiny, intermediate scrutiny, and the rational basis test provide different standards that courts use to evaluate constitutionality of all the laws based on the nature of the right involved or the classification used. The level of scrutiny applied can significantly impact the outcome of a constitutional challenge, which is why Bruin was so important. So now we have a very clear definition of how we're supposed to look at these cases, and it's not this 2-step test where there's a lot of subjectivity involved. It's more you have to show us that this law that you're challenging was back in the day, they had something like it or with the same spirit. And now most of the laws that we're challenging nowadays, they were not around. So it's going to be a lot easier for us to fight this because the government doesn't have anything to really answer with. So there's a couple case updates. I'm just going to get into one right now a little bit because I know that people are interested in this one. It's Mock versus Garland, and that's the pistol brace rule. So ATF made a rule stabilizing the ATF rule makes pistol stabilizing braces illegal to own due to being subject to the NFA restrictions. The NFA was the National Firearms Act that was back in the 1930s, and that's what made short barrel rifles, that's what made short barrel shotguns, that's what made all these little things illegal and having to get those tax stamps. And the funny thing about those tax stamps were when they made that rule back in the day in the 30s, it was a $200 tax stamp back then. So you had to be in the rich or the elite class to even be able to afford any of those things. Nowadays, $200 is still a big burden for people, especially when you're thinking about people that live in other states that can buy silencers, suppressors, things like that, where the tax stamp is probably more than the cost of the item that they're buying themselves. So back in the day, they really made that rule just to help out the rich and the elite, and they made it so that it was so hard to get so unattainable for the regular people that they thought that it was just a good rule so that no one could really have these things without actually making them illegal. Recently with these pistol braces, there were hearings in Congress to determine where they were at with everything, and the ATF director testified. He avoided pretty much all the questions he could during the testimony because they didn't want to make any statements. However, there were a few times where he did have to fess up and answer. And one of the things he said was owners who don't want to jump through the hoops, they may permanently remove their braces so that it cannot be reattached or replace the barrel with at least one that is 16 inches long, according to the ATF's final rule. The only exception is arm braces without a buttstock that can be shouldered like a rifle, which that is just like too much going on at one time. I understand you got to either take it off, but then the exception doesn't make any sense either. So there's a lot of gray area in this right now. A lot of people are asking me, hey, do I need to get rid of this thing? Can I keep it? Right now, it's hard to say one way or another because they technically can prosecute you for something like that. But if they did that, you would just you would make the challenge that it's being challenged at the higher courts. So then they would just have to wait for a decision on that to see if it's actually illegal or not. So if somebody came to me and they had that same issue and they say, hi, I got arrested for having this, and for my pistol brace with my pistol, I had an AR pistol, I didn't know it was illegal, and then they come and take it from them, we would just try and put that off as long as possible until this is decided, because right now there's just so much gray that I don't think any other judge would even try and make a decision on it right now. Except for unless they're at the higher courts, because in the federal courts they're trying to do that, but at the state level right now they're not really making any decisions on it because they can't. So that one, we will hopefully get some more clarification on this sooner than later, and that's definitely going to go to the higher courts. Maybe that's one that'll make it to the Supreme Court. There's a lot of questions right now about the ATF's rules and what they're actually legally allowed to regulate, and what the scope of the regulation is given by Congress. Because right now they're making laws with the stroke of the pen when they reclassify guns or make them illegal, and that's something that is consistently being challenged right now. So I know I'm running out of time. I went a little over, but thank you very much for sitting here and listening to me today. If you have any questions, I'll be around for a little bit afterwards.